Yes, I need orders and several, but...
Alright everyone, buckle in because today's courtroom session gives us two cases, two totally different legal messes, and both come with twists you won't believe. First up, we've got a small claims ruling where a company called Ballistics Removal completely ghosts the court after getting hit with a $1,400 judgment. And trust me, when a judge starts talking contempt, arrest warrants, and personal subpoenas, things get spicy fast. But case 2? Oh, that's where the emotional stakes explode. A car accident, an uninsured driver, or so it seems, conflicting insurance stories, a frustrated plaintiff without a car for months, and a dealer who insists the kid who crashed her vehicle was just on a test drive. And wait until you hear how insurance laws actually work in Michigan, because the outcome is not what most people expect. Stay with me because this one swings from tense to downright jaw-dropping.
But allegedly they're coming.
Okay. My eyes open.
All right, I think the live chat is off. I hope it is. Mr. Crick and Ms. Solomon, would you join me, please?
I'm here.
All right. First matter we're going to address is the discovery matter in Andrew Crick versus Ballistics Removal. The file number is 251629. Mr. Crick filed a small claims action against Ballistics Removal for $1,400.
One time,
We had a hearing and a judgment entered in that amount. That was on September 19th. By the terms of the judgment, the plaintiff is entitled to payment within 30 days of the date of the judgment, or they can pursue collections. Nobody appeared for Ballistics Removal. Mr. Crick filed a subpoena for a debtor's examination for Ballistics Removal. Bring him. All right, put him in the Zoom room.
He's in there.
Okay. And Gregory Myers of Ballistics Removal was served for today's hearing personally, and he is not here. The problem is the judgment is against Ballistics Removal, not Anthony Myers or Gregory Myers. Gregory Myers received a subpoena.
Here's where the courtroom temperature starts rising. The judge has already confirmed that Ballistics Removal didn't show up for the original hearing, didn't pay the $1,400 judgment, and now, after being personally served, Gregory Myers still hasn't appeared for today's debtor exam. That is a big deal. In civil court, especially small claims, ignoring a subpoena is one of the fastest ways to push a judge into enforcement mode. Notice how the judge stresses that the judgment is against the company, not the individuals? That's because legally she can't issue an arrest warrant for a business, but she can for a person who ignores a court order. So here's the drama. Greg Myers isn't just blowing off paperwork, he's blowing off the court. And when a judge starts spelling out your name letter by letter to prepare an order to show cause, yeah, that's when trouble is knocking. Let me ask you, does this look like straight-up avoidance, or is there any chance this was a misunderstanding? Drop your thoughts below.
Mr. Crick, have you had any contact with Mr. Myers since the hearing?
No, no, I have not.
I can't very well issue an arrest warrant for ballistics removal. I can, however, do an order to show cause for Greg Myers. See how I spell that. Meyers. For failing to appear for a personally served subpoena. If he does not appear for the order to show cause, I'm going to find that he's in contempt. I'm going to issue a warrant for his arrest, but I can't arrest the company. He was personally served and he's failed to appear. So we're going to have to set a show cause hearing. If he does appear, we can conduct a discovery hearing. If he does not appear, he's subject to contempt and a warrant for his arrest. I would set bond in the amount of the debt. You have an additional $55.40 in service fees. Did you have other costs?
No, not at this time. That was the only other thing that was added since the hearing.
All right, we're going to get another date. And if he doesn't appear for that one, I'm going to issue a warrant for his arrest. So if someone hears this on behalf of Gregory Myers of ballistic removal, I would suggest he contact Mr. Crick regarding this civil debt. All right, that's all we can accomplish here today, sir.
Okay. I have a question, Your Honor. Do you know when that will be, or I'll get that in the mail, or how? Will that
You'll get it in the mail. It might not be till after the first of the year. They're going to have to serve him again.
Okay. So I don't need to be concerned about that then?
No, it'll be probably in January.
Okay. I just want to make sure I know what's going on, that's all.
Are you still at Pleasant Street?
Correct.
All right, we'll get a notice to you there. You can appear by Zoom like this once again.
Okay.
All right, thank you.
Thank you, sir.
All right, Miss Solomon, would you join us, please?
Yes, I'm here, Your Honor. Can you hear me?
I can hear you. I can't see you.
Okay. I'm not sure how to do that. Hold on. Start video. Can you see
There
me
you
now?
go.
Okay.
Yes.
I'm not good with this.
No, it takes some practice. Mr. Neal is here with me at the courthouse. They put him in the conference room
Okay.
in case you guys need to talk. But let me talk about this case. This is file 252219 SC, Savannah Solomon versus Ron Neal. Mr. Neal is present in the conference room and Ms. Salmon is here by Zoom. Let me explain a little bit. Mr. Neal, you might have done this before, but I don't think Ms. Salmon has. You're in small claims court. It's a separate division of 3B district court. You can sue for up to $7,000 in small claims court. Neither party is allowed to have an attorney. There's no formal record being made of the proceedings. There's no appeal from the proceedings. Any decision made here is final. There's no appeal or rehearing. The decision is final. Either party has the right to ask me to remove the matter from small claims to the general division of the court, where you could sue for up to $25,000, have the right to an attorney, and have the right to appeal. But once we begin here, the decision is final. Do you understand, Ms. Salmon?
I do.
Mr. Neal, you understand as well?
Yes, I do.
Let me give you a proper name. All right, would you both please raise your right hand? You both swear or affirm to the best of your ability you'll interpret these that you will strike that. You both swear or affirm to the best of your ability that you will tell the truth to the best of your knowledge.
I will.
Yes, I will.
All right. I was giving you the interpreter oath, which we do quite often. We don't need an interpreter. All right, I had to study this case a little bit to see if I could figure out what was going on. This is a claim for $6,463.19. Miss Salmon was in an automobile accident where somebody crashed into her car, Constantine Road at Featherstone, I think it was.
Yes, Your Honor.
And sustained damage to her car. The car was driven by Adam Kaler of Maple Crest Apartments. The car belonged to Ron Neal, and allegedly the car was uninsured. Mr. Kaler got a ticket, which I looked up, which is file number 25907537SI. He got a ticket and promptly failed to respond to it. So he's about to get defaulted for failing to answer his traffic ticket. Failing to yield as a civil infraction. Under Michigan law, if you are not insured and you're in an automobile accident, you're not covered by the no-fault statute. And the plaintiff can sue for the entire amount of the damage. Under the current status of the Mini-Tort Law, they can sue for up to $3,000 for damages, but not the entire amount. We get lots of these cases because we have literally hundreds of uninsured drivers driving around with no insurance. Hundreds. And several times a year, one of those people gets in an automobile accident and causes substantial damage, and the other party's insured then sues them for $24,000. The accident report contained with the claim says that the defendant had auto owner's insurance. Excuse me, the plaintiff, Miss Salmon, had auto owner's insurance, and that Mr. Kaler's automobile, which was owned by Mr. Neal, says it was insured by West Bend Insurance. Mr. Neal, in his answer, claims that the vehicle was insured by West Bend Insurance. So, Miss Salmon, well, first of all, let me start with you, Mr. Neal. Who is Adam Kaler to you? Somebody that was buying a car from you?
Yes, he was on a demo ride that morning, and I put him on in the pickup on a dealer plate, and they go out and drive 10, 15 minutes. Well, 20 minutes later, he called me and said there's an incident. When he came back and everything settled down, he ended up taking delivery of another vehicle that day. But that's who Adam is to me.
All right, Miss Solomon.
Yes, Your
Mr.
Honor.
Neal contends that he is insured by West Bend Insurance Company.
Yes, Your Honor.
Tell me what you know about that.
Well, I reported the incident to my insurance, and Julie forwarded the information on 8/21 to West Bend, and they called me and my mom. My mom was a witness as well because she was in the vehicle, and they got my statement and they recorded it. Called them again.
Now,
and
who is that? Who is they?
The West Bend insurance people. I didn't get a name for who
The lady was.
yeah, the lady that took my statement.
In mine.
Okay.
So
No,
I did,
did you-
but Ron said he didn't want to make a claim because he didn't want his insurance to go up, but he was going to fix the truck himself.
Yeah.
So I'm not really sure who's going to pay for my car and like the court costs.
Now the energy shifts entirely as we enter case 2, and this is where legal nuance becomes crucial. Miss Salmon believes she's owed more than $6,400 because an uninsured driver crashed into her car, leaving her without transportation for months. Anyone would be furious, right? But here's the twist. The judge is laying out Michigan's no-fault system. Under it, your insurance covers your own damages, even if the other driver caused the crash, unless they're uninsured, in which case you can sue for the full amount. But Mr. Neal, the car's owner, insists his vehicle was insured through West Bend, and that the driver was only test driving it. This transforms everything. If the vehicle was insured, Miss Salmon can't sue for the full $6,463, only the $3,000 allowed under the state's Mini-Tort Law. The tension here is real. Miss Salmon wants answers, Mr. Neal insists the insurance process hasn't been completed, and the judge is trying to avoid issuing a judgment that could damage Neal's credit when the system is already designed to resolve this through insurance. So here's my question to you. Do you think Mr. Neal is genuinely trying to help process the claim, or is he trying to dodge responsibility by pushing it all onto insurance delays?
Well, if he's insured,
Yeah, is it the insurance?
then your insurance pays for it.
Well, I guess
He, under the no fault statute, you're in an accident with somebody else, he pays his damages and you pay your damages. If he elects not to make an insurance claim for his vehicle, that's on him. If he decides he'd rather just fix it than make a claim for it, he can do that. But his insurance company doesn't cover you. So apparently he is insured by West Bend Insurance, which means you can't sue him for this entire amount. However, you can sue under the Mini-Tort statute, even if he is insured, for $3,000.
Yeah, Your Honor, I just want the value of my car. I don't want anything more. I've been without a car since August 13th.
Mr. Neal, what's your response?
Well, from what I called my insurance agency this morning and talked to Lucas Singledecker at Preferred Insurance. And I had asked them if a claim had been filed, if she had filed a claim against West Bend against me, so she can get up to the $3,000.
Yeah.
And it goes back to a month or so ago, or a month and a half, when I received this letter, I got a hold of him and I said, hey, where are we at here? And he told me what she had to do. And I had talked to her about 2 weeks after the accident incident. And I had talked to Lucas, and Lucas told me what to do. I told her, called her back, gave her the information, and then I didn't hear nothing until I received the letter in the mail. And I called Lucas. I said, was there a claim filed against West Bend? He goes, they know about it, but there hadn't been a claim yet. The paperwork wasn't completely filled out. I said, okay. I said, I'll call you the day of we come to court. So this morning I called him, and he said paperwork has not been completed yet. And that's all I really know,
All right. Well, you have auto owners. Did you make a claim with your insurance company? Miss Salmon?
Oh, yes, Your Honor.
All right.
But, Your Honor, my mom's here. Can she be here?
Oh, sure.
Okay, she's gonna explain the insurance because she was helping me with this.
Well, Mr. Neal's correct.
Okay,
Normally, you make a claim with your insurance,
and
and
yes, I did.
if he's insured,
You did.
then
This stuff.
you can't sue him for the entire amount. However, your company could make a claim against his company for $3,000 under the Mini-Tort statute. So it sounds like that's in the works. But you can't sue Mr. Neal for $6,463 for this damage because he was insured. He's in the business of selling cars, and he has a blanket insurance policy. And this dumb kid went out and crashed into your car, got a ticket, blew off the ticket. It's now almost December. He hasn't answered to the ticket he got in August. He's going to get a default judgment. But if auto owners makes a claim against West Bend, I believe they'll pay the $3,000 Mini-Tort limit.
Yeah, all I know is my insurance said that they faxed the information to West Bend and that they have it and that they would take care of it. So they called us for the statement. So that's why I'm just confused on how to go about this.
What I'm going to do is continue this. I don't really want to do a judgment against Mr. Neal right now. He didn't do
Yes.
anything wrong. He
Yes, I
insured his
agree.
vehicle. He let a customer test drive it, and the customer didn't do too good. He's been dealing with his insurance company. Your company is dealing with his insurance company. I think what you're going to get out of this, Ms. Salmon, is the Mini-Tort limit of $3,000. But I don't want to enter a judgment against Mr. Neal because it'll go on his credit. And you sued him personally. I'm going to set this out. I'm going to continue this.
Okay,
to
thank you, Your
January
Honor. Yeah, I don't want to.
26, 2026 at 3:00. Hopefully by then the insurance companies will have worked this out.
What would you suggest that I do? Should I try to contact West Bend again?
No, you contact your own insurance company.
Okay.
Mr. Neal's talking to West End. Tell them that did you tell your insurance company you were filing a small claims action?
Yes, I did, Your Honor.
It wasn't your fault. Don't do anything.
I don't know exactly what kind of coverage Mr. Neal has. My son got in an accident in a car that I owned. He ran through an intersection and hit someone. She was very angry, very, very angry. And he just, there was no drugs or alcohol or anything involved. He just wasn't paying close attention. My insurance company simply paid the mini-tort limit, and that was the end of it. I'm not sure what kind of policy Mr. Neal has, but hopefully they'll do that. If they don't, I can enter a judgment against him in the amount of $3,000, which is the mini-tort limit. Then he can turn it into his insurance company and see whether they'll pay it. I'm trying to do this without having a judgment enter against Mr. Neal, seeing if the insurance companies can just deal with it.
Yes, thank you.
All right, you haven't lost, well, you're not gonna get everything you asked for because he's insured.
Yes.
So the no fault law controls. But even with a no fault law, you can still sue for $3,000. So, Mr. Neal, you need to see if you can get your insurance company to react to this. Perhaps just settle it with auto owners. If not, then we'll deal with it further on January 26th. Do you have any questions?
You say that's January 26th?
Yes, at 3:00.
Okay. So I need to get a hold of my West Bend
Yes,
and give them her name and the case number.
yes,
Or whatever.
and her, yep. Do you have a copy of that accident report?
She did give me, or you did, I do have one
Yes.
here.
All the information of the companies is on there.
Okay. Okay. Then, do I get back a hold of her then, or am I supposed to be in contact with her after I talk to West Bend? Or
Do whatever West End tells you to do. Hopefully, West End will simply, it's gonna be, auto owners is gonna reimburse her for her loss.
okay,
Then at some point, auto owners may, they aren't gonna let her double dip. They aren't gonna give her $6,000 and then West End gives her $3,000. But let's see if we can get somebody made whole.
Okay.
All right. What's your name, sir?
I'm Lucas. I was just here. I didn't realize it was digital. If they had any, Rod had any questions, I was here to help them out.
Oh, all right. Well, come on up here.
Where should I?
Right over there is fine. How are you connected to this?
I'm his agent.
Oh, all right. Lucas is here from West End, so that's very helpful. What we've learned, Lucas, what's your last name?
Shingledecker.
Oh, yeah, we met before.
Yeah.
Would you raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
All right. What we know is that there was an accident at Constantine and Featherstone Road. Mr. Neal was allowing a customer, Mr. Adam Kaler, to test drive a truck. Mr. Kaler ran the red light or a stop sign and he hit Ms. Solomon. He got a ticket for failing to yield, which he has not responded to. Ms. Solomon has submitted a quote of damages, the amount of $6,463.69. She can't sue Mr. Neal for that entire amount because he's insured and he's covered under the no fault statute. So do you confirm that Mr. Neal's vehicle was insured that day, the day of the accident?
Yes, it was.
All right. So what she can sue for is the mini-tort limit of $3,000. She's covered by auto owners. It sounds like auto owners has been in contact with West Bend. So what I did is I continued the matter to January 26th to see if auto owners in West Bend can work this out so that Mr. Neal doesn't get a judgment against him. Does that make sense to you?
Yes, and they should.
All right. You think West Bend will pay the mini-tort amount?
Yes. I've never had a situation where they didn't.
All right. Thank you for being here. It's very helpful.
Alright, before this session wraps, let's break down what we just witnessed, because this was a perfect snapshot of how small claims, insurance law, and real-world responsibility collide. In the first case, ballistics removal is officially on thin ice. With a no-show defendant and a personally served subpoena ignored, the judge is preparing to issue an order to show cause, and if Gregory Myers doesn't show up next time, a contempt charge and arrest warrant are coming fast. That's as serious as it gets in civil court. In the second case, things ended far more calmly. The judge confirmed that Mr. Neal's vehicle was insured, meaning Ms. Salmon can't recover the full $6,463, but she can get the $3,000 mini-tort limit. The judge wisely avoided entering a judgment that could damage Neal's credit and instead continued the case to give both insurance companies time to finalize their claims. The most likely outcome? Auto owners in West Bend settle the $3,000, Ms. Salmon gets compensated, and Mr. Neal avoids a personal judgment. A reminder for anyone watching, insurance laws vary by state and Michigan's no-fault system often surprises people. Your insurance pays you even if you weren't at fault. If you found this case as shocking, frustrating, or eye-opening as we did, hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns, legal insights, and real-time reactions. Your support helps us bring you more cases just like this.
All right, we're all on the same page. Mr. Shingledecker knows what Mr. Neal needs. Ms. Salmon, you can let your insurance agent know we had this hearing. January
will do that.
26th. And let's see if you guys can get this sorted out. Whoever needs to be paid the $3,000, whether it's auto owners or Ms. Salmon, will be paid. Mr. Neal won't have a judgment against him. And you guys can all live happily ever after.
Okay, thank you so much, Your Honor.
All right, and Mr. Shingledecker, thank you for being here. That helped paint the whole picture.
Yeah, no problem.
All right, you're good to go. And Mr. Neal, good luck to you.
Thank you.
All right, very good. All right, well, hopefully we won't be here because the thing will be settled. But if it isn't, as I indicated, Mr. Kaler got a ticket and he hasn't paid it or even responded to it.
Oh, jeez.
That's ticket number 25907-537 SI. All right, you guys are all good to go. Thank you, Ms. Salmon.
Thank you. Have a good day.
Okay. Mr. Neal, you're good to go as well. All right. Thanks, everybody.
Thank you.
All right. I'm thinking you guys are going to fix this.
Yeah, this shouldn't be a problem.
All right. Thank you.
Yeah, I'll get a hold of them tomorrow and make sure.
Okay. Very good. All right. That finishes our day. We still got things to do. Be back tomorrow morning.